Good morning, everyone, and welcome to the December 22nd, 2021 Policy Committee meeting of the Cheltenham School District. I will start with a roll call, and I'll call names as I see them on the screen. Ms. Jennifer Lohman.
Here.
Leah Mulhern.
Here.
Zachary Epps.
Present.
And I am Dan Schultz, and I am here. The next item on the agenda is approval of minutes. Could I have a motion?
So moved.
Is there a second?
Second.
Oh, I heard Ms. Mulhern, so Ms. Mulhern second. All in favor?
Aye.
Aye.
And the
Aye.
aye, those pass. All right, I think we can begin with the old business, which starts with policy 815 incident reports, which is for repeal. And we have two new board members on this call, so maybe if administration could just provide the same kind of context that was provided last year as a reminder of why these things are being repealed or modified, I think that will be helpful for them.
Yes, so good morning, everyone. Policy 815, incident reports recommended for repeal. This was just one of the items as we were going through the manual that was determined not really to be serving a purpose in its current form. And there's other reporting mechanisms for the types of things that were indicated in this policy. So that was the reason for the recommendation for repeal.
Thank you. Is there any board comments? All right, and I see no members of the public, so I will not ask for public comment. I'm mentioning this for the sake of recording. If a member of the public does appear and I miss them, please let me know, but I will keep an eye on the participants list. So that would move forward for actual repeal in the January meeting. The next item is policies 457, 557, complaint procedure for complaints not covered by collective bargaining agreement / CBA, which is also for repeal. And I'll also, let's talk about 357 as well, which is the update.
Sure.
So, thank you.
So no updates to this policy or regulation since last month. 457 and 557 are recommended for repeal because we're consolidating everything into 357. And just for the benefit of the new board members, previously there were three sections of the HR manual. There was a section for administrative employees, a section for professional employees, and a section for classified employees. And we're moving the manual to just have one section related to employees. And where different rules apply to different groups of employees, we just call that out in the policy as opposed to maintaining three separate sets of policies. So many times we're almost complete with the process, but you'll see a few more policies coming through where the 400 series and the 500 series policy are recommended for repeal, and the 300 series policy is the policy that will remain. And that's the background and the context for that.
Ed, may I interrupt?
Sure.
I do not have that listed as our next policy. I just want to make sure I pulled up the correct agenda.
Thank you. I am also seeing that the agenda I'm looking at has two numbers skipped. So I wonder if I'm looking at board docs.
Right, I understand.
So did I skip something? I see it on the screen as the order I listed.
You know what? I just wanted to also note, when I looked on board docs last night after our last meeting, to look at the attachments to the policies that we were going to be reviewing today, several of the policies came up, at least for me, as nothing there, kind of when I clicked on the PDF. So I'm wondering if maybe something got screwy when stuff was uploaded to the
Yeah, that's what I'm wondering.
Okay, hold on. I would Ms. Tolbert Jackson, which is there the policy in the email you sent, or I'm sorry, the agenda in the email you sent? Is that what you're looking at?
Yes, I mean, and they are the same policies. They are just listed in a different order
I
than they
see.
were originally inputted. So I don't know if it, when it was uploaded, something occurred. I mean, we can continue.
What do you see listed as the next item after 8:15?
Policy NAR 324.
I think that is, yeah. What
Yeah.
did I do? I think
No,
I might have just
it's just
misread.
listed differently. Because it is here, but it's
Right.
at the bottom. I mean, we can continue. All the
I see.
policies are listed, it's just in a different order.
Okay.
So we
Okay.
can continue.
Okay. I appreciate that, and I think just because this one is the public one, I don't know if it matters deeply. Again, there's no members of the public, but I'll stick with the order in board docs then.
That's
As long
fine.
as it does cover everything we want, and I thank you for pointing that out. All right. Well, all right, so we have the explanation. And is there any board comment on or public comment on the as publicly listed policies 457, 557 repeal and for 357 moving forward? Seeing none, those will move forward for.
Oh, I have to raise hand.
Oh, I'm sorry.
Just as a, no, I'm sorry, raise, last second raise. Just a point of clarity that this is, I've heard Mr. Diazio correctly. This isn't a modification of the policy. This is combining what was duplicate policies throughout.
That's exactly correct. And if you can see on the screen, the red lines and the green, that's the only language that has changed. You'll see it's non-substantive in this case. And even when we move to the AR, it's the same. You see a lot of changing he, she to they, making sure that things are capitalized the way they're supposed to. There's been no substantive changes to this policy or regulation.
I would actually thank you for that. But in terms of the moving towards inclusive language, in some ways it is substantive.
Sure.
So to see the gender neutral, I appreciate that. Thank you.
And just for clarity, substantive is a legal term of art, right, Ed? And out of curiosity for these, do they technically need to, since they aren't from a legal perspective, notwithstanding what Zachary just pointed out being meaningful, do they need to be board approved technically, since it's kind of reorganization of language? Or
given that the 400 and 500 series policy are being repealed, those would need board action.
okay.
In this case, we can probably, depending on what policy, there's a policy in the 0 section of the manual that talks about, if you're just correcting a mistake or updating someone's title, that you generally don't need board approval for those things. In this case, these revisions probably fit within that bucket, but just bringing them forward, for process purposes.
That makes sense. Thank you.
Yep.
All right, so we would move these forward then. 457, 557 for repeal, and 357 will move forward for adoption.
Correct.
Next item on my agenda list that I see is policies 452, 552, addressing disruptive behavior for repeal. And likewise, we can discuss the second at the same time, which is the adoption of 352. And
you'll
this
see
is
here,
the same consolidation, correct, Mr. Diaz?
Yeah, no changes to the policy, and in the AR, you'll see them here, just updating the policy and regulation 225 to reflect the correct title and some gender pronoun updates.
Yep. And I will note for those for the new board members, this is around employee disruptive behavior, not student behavior, or rather their relationship with, anyway, governing how the employee should act in that context.
It addresses, Mr. Schultz, the expectations of staff when they're dealing with disruptive behavior in the building. So it's not necessarily staff on staff behavior. It could be two students that are in a physical altercation or about to be, and what the protocol is that we would expect those staff members to follow.
Right. Thank you. Any board comments? Seeing none, these would move forward as well for respective repeal and adoption. And the next item I see is policies 455 and 555, professional dress and grooming for repeal, which are being consolidated into policy 355. So we can discuss all three of those as a package.
And then
Mr. Diaz, oh, yes.
the name of the policy changing to dress and appearance.
Thank you. And this is another consolidation and slight modification, or if I recall.
The policy language here in 355, you'll see we struck the prior language and replaced it. It's not, a lot of the language that was in the prior policy is still in this new language. It's just a little bit more general. Particularly in the administrative regulation, you'll see we added some language that was discussed last month about political advocacy. And just took a closer look at this one. It had been 10 or 12 years since the last time it was looked at.
Great, thank you. I will just mention, because it's around dress codes, I know that when we updated the student dress code policies, we had an eye towards, an eye towards, gender, making sure that nothing in our policy would create sort of gender-based disparities. I'm reading this language and not seeing anything that would. I just wanted to mention it to put on other people's radars in case there's anything that jumps out at them that I am missing. And if there is none, then I think we can move these forward as well.
Mr. Schultz?
Yes. Sorry, I keep missing your hand.
No, it's fine. Do I need to officially be called?
Yes, well, I did by saying yes, Mr.
Okay,
Epps.
cool. Thank you. Just week two. So why not gender? I'm wondering about ethnic discrimination. When I see the neat, groomed hair, I can think of a teacher with dreadlocks or an afro. How is that recognized in this policy in terms of neat, groomed hair and appearance?
So that's a good question. And I think, the times when, and maybe the admin team can chime in here as well, but generally, the only time I've seen with respect to employee dress where something like that would come into play. Sometimes I've seen it in the food service realm where health requirements might require, hair netting or things like that. And, employees will be expected to follow those requirements. I don't know that we've ever had, I don't recall a situation where we've ever had to take any action because anyone's hair or anything like that was in violation of our policy. Ms. Jackson, are you aware of anything?
No, we haven't had to take any action because of anyone's hair. Usually if it's any type of action, it would be dressing appropriately, such as something too short in the summer or too revealing. However, I do understand the concern. I just don't know how to change the language to make sure that it's not interpreted that way.
There's also a number of non-discrimination policies in the employee section of the manual. So anytime an employee feels that any policy, not just this one, is having any type of discriminatory impact, there's procedures for pursuing that internally and seeking accommodations. So that would also be how it would be interpreted. Does
Appreciate
that
that.
answer, Mr. Epps, your question?
Absolutely, it does, and it's good. It's encouraging to hear. There haven't been any reported instances of that, and so it's good to hear that the discrimination policies would then put a procedure in place, and language may not be needed specifically in this policy.
Great. Thank you, Mr. Epps, for that comment. My only understood if it's not necessary because it would be cross-referenced in every policy, but would it make sense to cross-reference the non-discrimination policy in this one just as?
Yeah, I can make a note to do that. I think that's a good idea.
Okay.
And that would be
for
that'll be a
board
non-substantive.
members, that's just whenever there's a related policy that you want to make sure to highlight, adding kind of a note at the bottom of the policy, or even a line in the policy referencing it, kind of helps gel that observation. So with that, this could move forward. See, and I will, Ms. Tolbert-Jacks, actually, when you were giving your examples, talking about clothing, it is tricky, but what is revealing, what is not revealing, etc. I mean, that is kind of the crux of the issue I was raising. I don't know if anything can be done about thinking through it, but I think the way we've handled it, excuse me, is to rely on the judgment of building administrators. And
yes, and if it's to the point where it's disrupting the educational environment, so it would depend building administrators, but they would also discuss it with me.
okay, that's great. All right, those will move forward, and I'm trying to get back to my list, which looks like the next item is 424, 524, and 324, which are personnel files, and another consolidation of everything into 324.
Yes, and with this one, there were no updates to the other than moving the legal references to the proper place in board docs. This policy was just last updated in 2019. The only reason for bringing this one forward was to carry out the consolidation.
Great, thank you. Any comments? Seeing none, that will move forward, and we can move on to new business. All right. I hope that these are the right order. Also, I should mention this again for the new board members, and we can cover this offline, but did you all get guidance on how to view the draft policies ahead of time? No. So I'll just very quickly, if you look in the policies after you're logged into board docs, the policies link, if you see that arrow, you can click that, and then it will have a drafts section. And that is where you can view the drafts. So, and in pantomiming that on my own computer that nobody could see, I have moved away from the agenda. Give me 1 minute.
That's great. Thank you, Dan.
Yes. So the first policy for discussion on my agenda that I see is policies 314, 414, and 514, management of HIV. Since this is a new policy, could Mr. Diazio or Ms. Tolbert-Jackson, could you provide some context around?
Yeah, so this one, and just to preface a lot of the new business, we had previously outlined agendas for the first half of the 21-22 school year. And so the items that are on this agenda are just the things that are sort of, I would call them cleanup things in the manual. They're not the most substantive things today. So in some ways, these policies for new board members who maybe haven't had as much time to review them, it's actually not such a bad thing because they're just they're policies that aren't necessarily relied on very frequently, but that we just wanted to get updated. So with 314, 414, and 514, I think it's the 14.1s, correct, Mr. Schultz?
Yes.
Thank you for that clarification. Yes,
Yep.
it is point ones.
So we've proposed making that policy 315 so that it's being renumbered. So policy 315 will now be the policy. And this just, there's really nothing new here. The law has not changed around this. We've broadened the scope of the policy to not just be about HIV, but also other bloodborne pathogens. And the administrative regulation just talks about general guidance on how you handle scenarios when employees have those conditions, and how you, particularly for employees who might come in contact, whether it be school nurses or folks that are having one-on-one contact with individuals that might have these conditions, the universal protocol that are followed, confidentiality requirements, having a plan in place to, ensure hand washing, all of those types of things. So I can go to the regulation and just kind of walk through it. There's a number of definitions here. And then if we scroll down, a lot of this was in the prior regulation, but we just repasted it here because it copy and pasted cleaner into a new document. So nothing changing here about internal process, just one of the final HR policies that needed to be updated and consolidated. This was also one of the ones, I believe, if I check the date here, had not been looked at since 1999. So Mr. Schultz, as you know, we've been looking at policies that are, pushing that 20-year mark. So that's why, again, it was the consolidation plus the date of last review on this policy.
Right. Thank you. Thank you for that very detailed context. And with that, are there any board comments? And I see Ms. Haywood has joined us. Thank you. I hope you're feeling better. And hi. We've covered all of old business and we are just starting new business.
Okay. The only thank you, Mr. Schultz, for taking over. I really apologize for being so late. Just the only question I had, Mr. Diazio, for this one is, I know that this is for bloodborne pathogens. Is there a corollary policy that we would need for something like COVID-19? I know that we have, obviously our safety plan that addresses how do you, quarantine, et cetera. But is there anything that we would need to memorialize in a policy for COVID-19 similar to bloodborne pathogens?
So we haven't seen any districts go in that direction because of just the constant changing of what we're seeing and the conditions changing in what feels like just real time. And to your point, the health and safety plan is the document where all of the rules and regulations around COVID-19 protocol would be contained. And the board, as you know, adopts and the original plan plus the updates to that plan. So we still don't have anything that we're recommending in policy, but it's been a question that gets asked frequently, by a number of districts, and we're continuing to just watch the guidance to see if and when it makes sense to bring something forward. That's where we've been currently.
Okay, thank you.
Thank you, Ms. Haywood. Any other questions from board or administration? And seeing none, this would move forward to first read. And again, for our new board members, who I'm sure already know this, but bears repeating sometimes, the process is things are presented at over 2 months. So there's a first read at the legislative meeting, which gives the public and the full board a chance to review and offer comments. It then goes back to the policy committee meeting as old business for another discussion. If there are no substantive changes, then it would go to adoption. If there are substantive changes, it would then go back for first read, and the cycle continues. The next item on new business is AR 321 political activities. I'll also just add this tidbit. ARs are not actually passed by the board. They are presented to the board out of pragmatism, I think, more than anything, but legally we don't have to go through the first and second read policies for ARs. And so this is just the administrative regulation, correct, Mr. Diazio?
Yes, so this was identified last month. It was identified that policy 321 did not have an AR attached to it. And I recall having a discussion. I know this committee saw this AR 321. I think it just never, and as you'll note here, the last modified date on this document was back in February of 2020, which was when we did the policy. The AR just, for whatever reason, never got carried forward and adopted. And so before we just posted it, almost 2 years later, we thought it would be helpful just to bring this AR back for the committee to put eyes on it one last time. And then we would move forward with posting it. But again, the committee did discuss this back in 2020, and there's been no changes since then.
Thank you. Sorry, I'm smiling because I saw a cameo appearance of an excited first grader in Mr. Epps in your case. Yes, thank you for that, and that does make sense and explains why this looks so darn familiar. So is there any comment on this administrative regulation for 321 political activities? Mr. Epps?
Would this cover, would this prohibit encouraging students to register to vote?
Encouraging students, I missed that.
To register to vote.
So this would only apply to staff member political activity on school campus. So we have a student freedom of expression policy that would govern students, but I actually see what you're saying. So if staff members were volunteering or supporting like a voter registration drive, would that count as political activity? And I would say no. Generally, when we think of campaigning and political activity, we think of advocating for a particular candidate or for a particular cause, not just general activities that would relate, equally to no matter who you were supporting, what cause you were supporting, what your philosophy, anything like that. So there would be nothing in policy that would prevent that type of activity. And a lot of schools do those voter registration drives. I know Ms. Haywood referred to it in one of her reports at the last board meeting, and there would certainly be nothing in policy that would prevent that.
Thanks for the clarity.
Thank you, Mr. Epps. Is there any other board comment? Oh, yes.
I'm sorry, I forgot to.
I see your hand now. Yes.
So along the same lines, kind of based on the last legislative report, would there be anything to prohibit us from encouraging all high schoolers to register to vote and providing them with a voter registration form that they could use? That would, obviously is nonpartisan. We're not telling them how to vote. We're just offering them an opportunity to register to vote.
No, I would see no prohibition there. And in fact, what might be helpful, so as in the guidelines here, we talk about campaigning on district property is prohibited. I think if we go to the policy, which is not on the agenda today, but that might be helpful because I think there's probably a definition of campaigning. So you'll see it here. It means actively soliciting votes or campaign contributions for a candidate. That's what we mean by campaigning. So just general civic activities, whether it be encouraging voter registration or having, I know a lot of times schools will do, student debates or things like that. None of that would fall within the context of campaigning. This really, comes into play if staff members are handing things out during the workday, or wearing clothing or having objects with them that are truly campaigning in nature.
Thank you.
Thank you, Mr. Diazio.
Sure.
Trying. All right. And just to be clear, campaigning could simply be wearing in theory, wearing a button or having a button on a bag, correct? And that would be captured by this policy or this AR.
Correct. Yes.
Okay. Great. All right. This will not move forward to first read, but would be presented as informational at the legislative meeting in January. And I say not move forward simply, I mean procedurally it won't, not to say it's not given a thumbs up by this committee. The next item on the list is, apologies for the background, policy 604, tax waiver requests. And this is a new policy. So again, if we could have some context, that would be helpful.
This one, I believe, I don't think this one is new.
I'm sorry, I mean,
Oh,
it's new business.
I see what you mean.
Yes.
It's new for discussion. Yes. So this one was last updated in 2008. It was one of the only policies in the 600 series, along with 621, which we'll look at in a moment, that was older, that hadn't been looked at in the last several years. And we just looked at it to bring it up to, just taking a look at it as part of the normal course of review. We also realized that there was no language in here about how tax waiver requests by residential property owners are handled. And that topic has come up a couple times in the last several years. And so we wanted to just memorialize what the current practice was. And as I'm looking at this, this should say residential here, not resident. So I'll make that change.
Thank you, Mr. Diazio. Is there any board comment?
And just practically speaking, as you can imagine, there's many taxpayers in the district. The tax bills go out around the same date every year, and they're due around the same date every year. And taxpayers are on notice that those taxes are due at the same time every year. And the purpose of this policy is just to say, essentially, you have an obligation to pay the taxes, and we don't waive the penalties or the interest if you don't pay for reasons like not receiving claiming you don't receive a bill or something like that. There are times, and I've seen cases before where the bank has made an error and they've not deposited the funds in the correct account. Certainly that would be rare and extraordinary circumstances. But if the school district had a policy of granting requests for anyone who claims that they didn't receive a tax bill, you'd be dealing with dozens of requests every year. Thank
you. Ms. Lohman, I see your hand.
I just had a question about where it says nonprofit entities. Do we have a policy, or is there maybe an AR about, or something about the pilot payments? Or should those be referenced here?
So pilot agreements are those would get board approved. We can add something in here that says that it's really not a tax waiver. It's actually that the taxes are not due. So it's fundamentally, it's a little bit different. So I would say, I don't think you need it in the policy, but if there was a desire to have policy language around it, we could look and see if a different policy would be appropriate. Those would be my initial thoughts, but I think that's a good question.
Yeah, I could see where it would fit in a different place for sure.
Yeah.
But it just sort of occurred to me that perhaps, I know that we've been talking about that a lot, and we've been working on that a lot, and so
Yep.
maybe having some reference to it might be good.
Thank you, Ms. Lohman. Apt question. Are there any other board comments or questions? And I see none. So one question I had was around the rare and extraordinary circumstances. Would it be appropriate, or would it actually be would it backfire to actually list examples? Right now we say what that doesn't mean, but maybe one, e.g., tornado took out a house. I don't would it make sense to explain what we mean by rare and extraordinary circumstances?
We could do that. These would get presented to the board, and it's really up to the board to determine what those circumstances would be. Again, I think if we were going to put an example in, the most common example that I see is a bank error where the taxes were actually paid. Maybe they were deposited to the wrong account or attributed to the wrong taxpayer. So Mr. Schultz, you pay your taxes, they're paid timely. The bank attributes that payment to a different taxpayer, and you get notification 2 months later that you're being charged penalties and interest because your taxes were late when it really was no fault of your own. You paid the taxes. That's generally considered a rare and extraordinary circumstance. That's the one I see most frequently.
Okay. Although I will add I do pay my taxes on time. That said, my mortgage company, this is a relevant story for the example you gave. My mortgage company didn't pay the taxes for a side lot, and I caught it. I paid it personally. Had I not, however, would that have counted as a bank error, or are you really referring to bank errors on the receiving side? And the reason I ask that is because if we're going to say bank error, generally this is maybe the risk of giving examples.
Sure.
So
Ultimately,
I suspect that those fees would still be due. I mean, then it's on me as the mortgage holder to yell at my mortgage company to make sure they're the ones that pay the fee instead of me.
correct. And ultimately, again, it's really up to the board to decide in any given case what the if a residential property taxpayer comes forward and sends a letter to the business office or to the superintendent, outlines their circumstances, the board will consider that, and the board gets to decide in the context of what the taxpayer is saying.
Got it.
Is this sufficient?
Okay. I'm satisfied not having examples then, understanding that by not having examples, it may be that a board in 10 years is a different set of standards, but so it goes. They would update the policy if that were the case. So if everyone else is comfortable, then this would move forward to first read. And I'm not seeing any disagreements, so we can move to the next item, which is policy 621, local taxpayer bill of rights.
Yes, 621. Local taxpayer bill of rights is a provision of the school code. It was adopted back in 1998. And the intent of the language, and actually I need to double check that. I actually don't believe it's in the school code. It's in the tax reform Act from 1998. But anyway, it's a legal requirement that school districts have a process for taxpayers to challenge the assessment of certain taxes. These don't apply to property taxes. There are things like business privilege taxes. It could be the mercantile license tax, earned income tax. And if there's a question or a concern that a taxpayer has or that the district has about the amount of money that a taxpayer is paying in, that there just has to be a process for how those requests are handled. And, you know, both parties are entitled to certain due process rights. There's a right to an appeal. And so this policy basically tracks the law to say, if in fact there is a question or a challenge to any type of tax that falls within the jurisdiction of this policy, these are the procedures that apply. I have never actually seen anyone file a challenge under this provision of the law. I've checked with a lot of other colleagues, and these things they just don't really ever come up. So I'm not aware, I can't tell you in Cheltenham that you've ever had one of these since 1998, but we do recommend maintaining the policy.
Thank you, Mr. Diazio. Is there any board comment? Ms. Haywood.
Thank you, Mr. Diazio. Is this now considered to be the local taxpayers' Bill of Rights? I think there is reference later that we would adopt or develop a local taxpayers' Bill of Rights.
I can check with what I'd like to do. I can check with Mr. Linderman to see if there's a document that exists in the business office already. If there's not, it might make sense to develop something. I have seen some districts that do have a set of procedures that are a little bit more detailed. The reason I pause and why I don't know whether they exist is because, again, the frequency that these things come up. But I'll find out from Mr. Linderman if someone in the business office might be aware if something exists. And if not, we can certainly take a look and see if it makes sense to develop something.
Yeah, and if we do have one, I think we could just attach that.
I agree with that. I think that's, yep.
Thank you.
Thank you, Ms. Haywood. Any other board comment? All right. And would that attachment be a literal attachment, or would it be in the form of kind of an administrative regulation, or is
it probably would make sense to be put in an AR. The actual document could be the AR itself.
right?
So we can, depending on what it looks like, I think we can determine where and how it should be attached.
Right. Thank you. And in either case, it might be presented at a future policy committee meeting.
Yep.
Wonderful. All right, that will move forward for first read. The next policy is policy and AR 916, volunteers.
Yes. So 916, this was one where the administrative regulation just needed some cleanup, but we also took a look at the policy here. Not too many changes substantively to the policy, but I'll go to the AR in a moment. And I can point out some of the things that were different. So under the prior policy, there were different categories of volunteer, and I'm looking for, I think they were called covered volunteers and non-covered volunteers, and those weren't necessarily, to my understanding, the terms that were being used internally. What you have is you have volunteers that, because of the nature of their service, they need background checks and clearances, And then you have other volunteers who have no direct contact with children. They're not responsible for the supervision of children, and they don't need clearances. So for example, if you're going to be chaperoning a field trip and responsible for children, you need clearances. If you're coming in for American Education Week and you're going to read a book in a classroom for 20 minutes, where the classroom teacher is going to be in the building or in the classroom, you're just coming in, you're more a visitor at that point. And because you're not responsible for children, because you're not going to be alone with children, those would not be cases where you necessarily would need to have clearances. So we outlined the requirements here in the administrative regulation for which volunteers need clearances. That's what's outlined here. The timeline, so every 60 months, that's the current legal requirement. And then other provisions that apply, which basically just track the Child Protective Services Law, which is where all of these requirements are outlined for reporting arrests, reporting convictions, and procedures for volunteers being approved. So that would be the general summary of what's in the AR. And I think I saw at the beginning of the meeting, I think Dr. Smith is here. If there's anything, Dr. Smith, that you see that should be tweaked. I know that when there's volunteers that are approved, they generally, I believe the volunteer approvals come through your office.
That's correct.
Thank you. Are there any board questions? Ms. Mulhern.
Yes. Can you go back, sorry, first to the 60-day, what was the 60-day thing before I get to?
60 months up here.
Oh, 60 months. I was like 60 days. I thought it was 5 years. So it was
Yeah.
months. Okay, that
Yep.
makes sense. That was just my brain. It's not enough coffee. I guess my question, having been a parent and a volunteer who has recently, gone through some, probably due to actually apply for my clearances again. Does it talk in here, or I don't know if this is appropriate for the ARs or not, about who, I know that the forms go to Dr. Smith's office, they get approved by her, they get approved by the board. Then what happens then? They go back to the building? Like, who's actually checking and monitoring the people coming in and out of the building to be sure that they have the appropriate clearances for what their activities are? Is that an AR? Would that be?
I'll let Dr. Smith, if she can, chime in on that one.
So my office maintains a spreadsheet that is accessible to all school secretaries. So prior to a new volunteer coming to the building, the secretary has access to look at that list to ensure that the new volunteer is on our list. And in 8 instances where they have not been on the list, they call Ms. Peters in my office to see if that person should be on the list, or if we have information in the pipeline and they're on their way to being approved. But my office maintains it and shares it with all of the schools.
All right, thank you.
Thank you, Ms. Mulhern. Ms. Haywood?
Really a minor correction to be consistent with the AR. In the policy, we have language that says any volunteer position or volunteer may be eliminated at any time. I think we probably wanted to say, as such, any volunteer position or services of a volunteer may be eliminated at any time. I know we're not eliminating any volunteer.
Thank you for that critical clarification, Ms. Haywood. Any other board comment? I have one question around, well, I don't know, safety and training. And so I know that organizations that work with youth, Scouts, for instance, have a series of training for all members or all volunteers that are mandatory around child safety. Mr. Diazio, you mentioned, being anyone who might be alone with a kid. I know that the policy actually is anyone who might be in contact with a kid, which I think is actually correct. But also in training, there would be very strict guidance and ideally rules around you're not even allowed to be alone with a kid as a volunteer. You have to have at least one, two adults when interacting with children. So this is actually a two-part question. The first is around, would it be wise, is it standard practice? I imagine it's not, or it would have been included, to require youth safety training for our volunteers who are going to interact with youth. And then the second question is, do we have rules, policies, and procedures around enforcement of best practices related to youth safety for our volunteers?
So, and I'll say a few things and then Dr. Smith can add anything. I recall, or my understanding is, you'll see this last sentence in the regulation that volunteers shall attend orientation and training sessions as appropriate to the nature of the volunteer service. I think this question came up the last time we looked at this policy in AR, and the thought was, yes, the district does provide guidance to different volunteers as to what the rules and expectations are, but it's not necessarily a district-wide training session because it's more tailored to the scope of what the volunteer is doing. So if you're going to be on an overnight trip with children, chaperoning an event, the guidelines that you would be expected to follow that maybe the building principal would review for you are going to be very different than if you're coming in and going to be supervising the end of the year party that's on the playground outside of school. That was my understanding from the last time we had discussion. In addition to that, there's procedures here for reporting child abuse. So anytime a volunteer sees something, there's other policies that talk about things that they should be doing with respect to reporting that type of behavior. And we did build into this policy language around confidentiality, because to the extent that any volunteers have access to confidential student information, of course, they're expected to maintain the confidentiality of that. Dr. Smith, I don't know if you have anything to add, but that was sort of what I recall from prior discussions.
No, that's absolutely accurate. And just an example of some of the confidentiality things that may come up. If a parent is chaperoning a trip and there's a student on the trip who has a nurse because of a medical condition, that is something that we're expecting those volunteers to keep confidential. So that's just an example, but everything you outlined is accurate. It is case by case, duty by duty type of training that is available to our volunteers.
Thank you. And I wonder if, and that does make sense to have that. I guess my question then is, what is my question? I know there is generic child safety training that regardless of whether you're attending an event in a library with a whole bunch of other adults or having an overnight camp, volunteering, there are sort of universal rules of thumb, because even in the event where you're doing an outside party, a volunteer might bring a kid who needs to use the bathroom over to the bathroom, right? There might be circumstances where there are places where there's more quote risk or whatever it might be. So would there be merit to considering kind of for anyone who's going to need clearances to have some kind of training that is a 12-minute course that we just are subscribed to and it becomes mandatory for all volunteers to participate in? We don't run it, it's training.
One of the things, Mr. Schultz, that I should have pointed out before we incorporated policy 860 by reference in the volunteer policy. Policy 860 is the maintaining appropriate boundaries with students policy. It applies to, by definition, it applies to volunteers here.
Mhm.
And there's a list here of 18 different categories of conduct that would be considered not appropriate. This would be
Right.
so this exists. There's language on electronic communications. I think that addresses some of what you were just talking about, but I'm just trying to, in real time here, think through whether there's anything else. But I wanted you to be aware that
That's great. Yeah.
all of these requirements apply.
Right. And for what it's worth, there's the policy, that's very helpful. And then there's the training to help people know the existence of the policy, the expectations, and the best practices, which adults would then, by knowing, they could see if other adults are potentially exhibiting dangerous behavior, and potentially prevent an incident from occurring by not allowing it to occur. This is, I think of this, I mean, this is the AR, and I know we'll be revisiting this next month. Maybe an actionable thing, rather than spending more time on it, would be if there are other districts that have language around trainings or practices around trainings for child safety. That would be, and even looking at youth organizations and what do they have in place. I know Scouts, because of what they went through as an organization in the failure of keeping their youth safe, they're now have a lot of good stuff. Maybe that would be a model. And we haven't had incidences as far as I know, and but we want to keep it that way. So that was it. That was my question.
Yeah, I made a note to
yeah.
check in on that.
Thank you.
That's a good point. Yep.
And obviously, if I'm in the minority with this question, then I don't. Okay, I see heads indicating I'm not in the minority per se. Let's see the next. So thank you. And I know we're at our hour, but I think we only have one more. So this would move forward to first read and will be revisited as old business for second read in January. And then the last item on our agenda is policies 323, 423, and 523, which are being consolidated into policy 323, use of tobacco and electronic smoking products.
Yes, so this is sort of self-explanatory. This is the staff level policy on tobacco, and added some definitions in here to more clearly define what's prohibited. But that was really the big change. Clarified that smoking cessation products don't constitute the prohibited items. And then the reporting, which was already it's part of the Safe Schools reporting. So added that to the policy. Again, nothing really operational here. It's changing.
Thank you. Any board comment? And I am seeing none. So I think this would move forward as well to first read. And that, unless I'm Ms. Tolbert Jackson, unless there's something on an agenda I am missing, I think we covered everything. Is that correct?
That is correct.
Wonderful. Thank you all. And I think we just need a motion to adjourn.
So
I heard Ms. Lohman first and Mr. Epps second, and all in favor?
Aye.
Aye.
Thank you.